Here we go with part 2, landlord-tenant law, and some of the requirements for being a tenant. This all involves real property. A lot of people buy real property and then lease it or rent it as a business. So, landlord-tenant law. A lease allows, exclusive use of the property. So, for a specific period of time, or sometimes for an indefinite period of time, as we'll see as we go down through here. And sometimes it's called a leasehold estate. Let's see if we have that exactly right. A leasehold estate is an interest in real property that gives the tenant a qualified right to possess and use a property for a limited time under a lease. So, if you're renting or you have a lease, it is called a leasehold estate. And there are two types at this point. One is a fixed term tenancy, and that is talking about I will lease or rent a piece of land for 1 year exactly. After that 1 year is up, my leasehold is up, and I would have to have another lease if I wanted rights to that land. Typically, a fixed term tenancy has fixed payments monthly or weekly or however, by maybe every 6 months. A periodic tenancy is a lease period that is indefinite, but there are fixed payments or lease payments for the property. And a lot of states have it as if a lease runs out, that if nothing else happens past that point, that lease is still in effect until it's voided either by the tenant or the landlord. So it's an ongoing lease for an indefinite period of time. There's also a tenancy at will, which means it can be terminated at either time by either party, sort of like that employment by will. Or a tenancy at sufferance, which means somebody continues to occupy the property wrongly after the lease has run out and they've been asked to leave. And that usually leads to eviction. So a lease agreement is a statute in writing for over 1 year. It has to be in writing. The statute says that it has to be in writing if it's for over 1 year to be valid. It describes the property, the length of the lease, and how and when the payment is to be paid. Probably you would also want to have on there the name of the leasee and the leaseor. And you really want to make sure, if you are in the business of renting property, that you have a good lease. So many times people will go to a lawyer for the first draw-up of the lease to make sure everything's covered. We have a question here, and it's not even marked in red. So we're going to put that right there. Go to the question while I mark the rest of the questions for everybody. We won't have too many questions in this one. So, are you done with the question? Okay, let's start in with leases continued. And that's the rights and the duties of landlords and tenants. Possession rights: the landlord gives access to the tenant, full access, and they are to be allowed, the tenant, again, that quiet enjoyment without intrusion by the landlord. And if that requirement is breached, the tenant can terminate or sue the landlord. Or, on the other hand, the landlord, if the tenant breaches anything that's in the lease, such as doesn't take care of the property, doesn't make payments, they can evict with the tenant for not following the lease's agreements or requirements. And there's something called constructive eviction, which is the reverse. where the landlord fails to uphold the lease, so the tenant will move out and evict themselves, in essence, and usually sue the landlord for a breach of contract. So then you have use and maintenance, and the tenant has any use of that property that is legal. It cannot injure, and it's a strange way of putting that, the landlord's interest, meaning you have to take care of the property. You can't devalue the property. And usually the tenant is not responsible for normal wear and tear, which would be needing to have to repaint or needing to replace carpets, say if the tenant were there for 10 years and the carpet needed to be replaced. That wouldn't be the tenant's responsibility, it would be the landlord's responsibility. For use and maintenance on the landlord side, the landlord has to maintain everything in good repair. There's this implied warranty again of habitability. And that literally means that you can inhabit the property, and you're safe. The environment is good. It's a healthy environment for you. So if it's not maintained, and the tenant has to repair something to continue living there, that can be deducted from the rent payment. They can cancel the lease if it's terrible, such as a great big hole in the roof, and they can sue for breach of contract. So it's kind of a balancing act for the tenant and the landlord. They need to take care of the property on both sides of the equation. For the tenant, they must pay the rent even if they're not occupying the building. And now that's only in the case of they voluntarily are not occupying the building. Let's say that there's a disaster, it burns, or the whole area has been evacuated for 2 or 3 months. Then the tenant does not have to pay. So there's a little bit of common sense needed in when the rent needs to be paid. So we have another question. Sorry, it's not in red, but at least I saw it. Go hop over, do that one. And then we're going to talk about how to transfer lease rights. So the landlord, the tenant becomes, let's look at the landlord side. If the landlord sells the property and he still has tenants in there, he or she still have tenants in there, the tenant becomes the tenant of the new owner, and the new owner must abide by the existing lease until that lease were to run out, and then they could rewrite a lease in their own to their own requirements. So from the tenant standpoint, the tenant can assign a lease to somebody else if they get the consent of the landlord. Again, you always have to have permission. Depends on how the original lease was written also. If it's accepted, okay, the acceptance of rent from the assignee waives the consent requirement. Now, what the heck does that mean? That means that if you assign it to somebody without permission, and the landlord still accepts that rent from the assigned person, that means they accept and give permission for that assignment, so it can't be revoked. But an assignment doesn't release, okay, the original responsibility of the first tenant that assigned the lease. So there are some things that you have to look at. It's always best simply to talk with the landlord and see if it's all right to assign a lease. In most cases, as long as the person you're assigning it to has a good record and is agreeable with the landlord, it's going to be acceptable. But you have to work with the landlord. A sublease transfers a lease for a short period of time, same requirements as an assignment. Again, to have a sublease, that has to be allowable by the landlord. So you always have to check with the landlord and make sure everything is okay. Otherwise, you can get into a lot of trouble, as can the person who has, thinking they have rented an apartment, moves in and finds out that, oops, they can't live there and they have to move out, and then things can get somewhat uncomfortable. It looks like there's a question here, and that takes care of part 2, and landlord and tenant law. Interesting, and I'm sure you've all encountered or will encounter landlord-tenant law. So finish your question. I'll see you in class. Thanks for listening.